Good afternoon. Thank you for joining us at Foster Swift for the Social Media Use by School Employees webinar. Glad to have everyone online with us today. This is a fairly short webinar, probably 30 minutes or less. We know that school officials are busy, so we try to present the information that you need and let you get on your way. Because of that and because of the number of attendees today, you can submit questions and I will respond to those by email within 24 hours. So please do feel free to send over your questions as we go through, and I'll make sure that you do get answers to those. All right, let's get started. As a quick overview of the presentation today, I'm going to begin by touching on something we're all aware of, the prevalence of social media, and briefly some of the benefits of social media for schools, and then dive into what I call the worst case scenarios, times when social media use has gone wrong for school employees. And then digging into the legal part of this, I'm going to talk about discipline versus the First Amendment and looking at official versus non-official speech and matters of public concern and balancing the interests. And specifically, how do we balance the First Amendment rights of teachers and other school staff against the interest of the school in doing what it needs to do, educating students and running a smooth operation. And then I'm going to close with some best practices for schools. All right, well, we are all certainly aware of the prevalence of social media in our lives, from Facebook to Twitter to Snapchat to probably new software emerging every day that maybe I don't even know about anymore. It is, frankly, everywhere. As of November of 2016, 79% of online adults are using Facebook. And that percentage is even higher for adults aged 18 to 29, 88%. And 30 to 49, 84%, which that age range is going to capture a lot of your school teachers and staff. 24% of online adults use Twitter, and 32% of online adults use Instagram. So social media certainly is no longer something that's just for college students. Back in 2005, only 5% of adults were using social media. And I remember being in law school in 2005, and the sense being that if you wanted to be a professional, you would not use social media because it had this negative connotation. And clearly that's not the case anymore, where an overwhelming majority of online adults are using social media. And social media can certainly be a great thing. We all do use it a lot, and schools can certainly use it for good. It allows for easy communication with parents. You might have a school Facebook page for events, alerts, school closings. You might have a secure class website to post assignments and grades for parents to access. You can use it for community outreach, recognition of team achievements, whether it's Odyssey the Mind or sports events, fundraisers, PTO events. There's all kinds of ways that you can use social media to connect with parents and the public. Professional development, keeping on top of trends, sharing research, curriculum ideas. There's a lot of very positive ways to use social media for that. And of course, networking with colleagues and building those lasting relationships. So certainly the message here is not that social media is bad. In fact, can have a lot of very positive uses. But things can go wrong. This is Carly McKinney. Carly McKinney was a math teacher. She no longer is. She's a 23-year-old math teacher from Colorado, and she posted some racy photos on her Twitter page, along with tweets like, "Watching a drug bust go down in the parking lot. It's funny, 'cause I have weed in my car in the staff parking lot," as well as naked, wet, stoned. This was the only picture that I felt comfortable putting on a presentation of hers, because a lot of them you would have to blur out. She was not using her social media page in a very responsible way. Some other worst case scenarios, the one on the left was an earlier case that got notoriety a few years ago. This college senior was a student teacher, and she actually told her students to go visit her MySpace site. You know this was a few years ago because it was MySpace, which nobody really uses anymore. But her MySpace page criticized her boss and had this photo with the caption, "Drunken Pirate," and she lost her student teaching position as a result of that. More recently, this one was on the news in the last year or so. This is a Georgia teacher who in numerous Facebook posts called First Lady Michelle Obama a gorilla with some obvious racist tones there. things did not end well for her either. So it's easy to point at the nightmares, and I'll just point out a couple more from the NEA's Social Networking Nightmares article, and there's a link at the bottom. If you want to get the presentation, I should point out now, email us. I'll send you the PowerPoint. You can click to these links to read the full articles. A couple of excerpts from this one, though. The Charlotte Observer reported that an after-school staffer from Charlotte was fired for his Facebook comment that he likes chilling with his, I will not say the word, and a suggestive exchange that he had with a female friend. Similarly to probationary teachers face termination for their Facebook musing that, quote, I'm feeling pissed because I hate my students, and, quote, I'm teaching in the most ghetto school in Charlotte. The Washington Post published a front-page investigative piece entitled When Young Teachers Go Wild on the Web, quoting one DC teacher's Facebook page that said, Teaching in the DC public schools, lesson number 1, don't smoke crack while pregnant. A special ed teacher wrote on her page to a student, you're a retard, but I love you, and posted a photo of herself sleeping with a bottle of tequila. It always astounds me to read these stories because you would think with social media being as prevalent as it is, people would know by now not to do these things, but they still do. And then as a school administrator, it becomes your problem, because these issues are then brought to your attention by parents, students, sometimes even the press. So then you're faced with disciplining that teacher. And when a school disciplines a teacher for an inappropriate or offensive social media post, that teacher might come back to you and say, I have a First Amendment freedom of speech right to post what I want, and you can't discipline me for it. And your discipline is illegal retaliation for exercising my constitutional rights. So that leads to the dilemma. Does free speech protect these posts, these often inappropriate and offensive posts, and what rights do teachers have or other school staff to post those? So the answer, of course, is the answer you often get from a lawyer, which is it depends. But we have a little bit more guidance than that. First, we have to distinguish between speech in an official capacity and speech in a non-official capacity. So official capacity is when the teacher's actually up there in the classroom and they're talking. They are teaching. They are talking while they are teaching, or they are performing their job function. They're not speaking as a private citizen. They are doing their job at that time. That speech is subject to discipline. That speech in the classroom or on the field if you're talking about a coach. And there's a Supreme Court case that says that. So that's not really what we are dealing with in this presentation. We are talking about these on their own time social media posts. And that gets to speech in a non-official capacity, where the analysis is more nuanced. So there was a case from the U.S. Supreme Court in 1968 called Pickering versus the Board of Education, and a lot of you have probably heard of it before, and this may be a refresher. But it talked about this balance of how we balance the rights of teachers and the rights of schools when you have speech like this. And that case said, the problem in any case is to arrive at a balance between the interests of the teacher as a citizen in commenting upon matters of public concern and the interest of the state as an employer in promoting the efficiency of the public services it performs through its employees. That's the balance. So here are some guidelines that we take from that Pickering case. When we're doing this balancing test, we have to look at some factors. Those factors include whether the statements were directed at someone with whom the employee would normally be in contact during the course of his daily work, with the idea being if this is somebody they're dealing with, then this may affect their ability to perform their job or the school's ability to function. Number 2, whether the statements impact the ability of the district to maintain discipline by immediate supervisors or harmony among coworkers. Whether there was evidence that false, defamatory statements damaging to the school district or its leading public officials were made, knowing they were false or made with reckless disregard for their truth. Whether the statements can be shown to have impeded or can be presumed to impede in any way the teacher's proper performance of his or her daily job duties, and whether the statements interfere with the regular operation of the schools generally. So in practice, generally, public employees speaking in a non-official capacity, the default rule is they have First Amendment rights. You're still a citizen even if you're a teacher when you leave the classroom. And so public employees can comment on matters of public concern, and that's generally going to be protected by the First Amendment. So you're allowed to have social and political beliefs, even controversial ones, and those are generally going to be protected. But that protection may be limited if the speech would potentially interfere with or disrupt the government's activities, such as interfering with the school's operation or teachers' ability to perform their job, and, this is the balancing part, and the potential disruptiveness outweighs the employee's First Amendment rights. I should note that if it's not a matter of public concern, the comments are not protected by the First Amendment, and I'll explain the difference between those two right here. So generally protected, subject to balancing test, are these comments or speech on matters of public concern. This would include but not be limited to comments on instructional methods, testing, curriculum, board action and policy, school funding, and political and social views. So if the speech in question is a Facebook post that is a scathing commentary on a recent decision of the school board, or if it is a commentary on school funding or charter schools or any of these other things, that's a matter of public concern, and it's going to be subject to that balancing test. Other speech, when it is not a matter of public concern, is generally not going to be protected, meaning that they can be disciplined for it. And courts have found that to include complaints, including complaining about administration, personal matters, obscenities, and sexually oriented or racist statements. A lot of the things that you saw at the beginning of this slideshow. Now you can see how there would be a fuzzy line where you could have something that is both a criticism of board policy and a complaint about administration tied together in the same speech. And so that's where there is a balancing, and the court may have to kind of parse out and figure out which category it should fit in. Here's a depiction of how that balancing test works. So you can see when we do have speech, again, not in an official capacity, but as a matter of dealing with a matter of public concern, we have the speaker's right as a citizen to comment on matters of public concern versus the interest of the employer to promote the efficiency of public services. And that's the weighing, the analysis that has to be done. And if it's done in the context of a court case and a lawsuit, it's going to be the judge or the jury kind of making that fact-specific analysis. So let's see how that has actually been applied by the courts, because it's not easy. It's not a black and white line. It's not an easy math formula that you can plug in the facts and get an answer. It is very fact-specific. So let's look at some facts. The first case is Richardson versus Becken, and in that case the teacher had a personal blog that described an administrator as a smug know-it-all creep who had a reputation of crapping on secretaries, and similar posts in that vein. So the school transferred him to a different position, I presume to work with a different administrator. It wasn't clear. And the teacher sued, alleging retaliation. The school won. And the court held that that speech had a significant deleterious effect on the district and that the school's legitimate administrative interests outweighed any free speech rights that the teacher had. Now, in some of these cases, the court doesn't definitively decide whether it's a matter of public concern or not, because it may be in that gray area. And instead, in those cases, what the court may do is find this may not be a matter of public concern, in which case it's not entitled to free speech deference. But even if it is a matter of public concern, we are finding that when we put the facts on that scale and we weigh it, that the school's interests outweigh the employee's First Amendment rights in this particular instance. So another case is in Ray O'Brien, where a first grade teacher in New Jersey worked in a school where her students were predominantly African American and low income, and she posted a lot of bad stuff on Facebook, saying she was not a teacher, she was a warden for future criminals, and suggesting that her first graders needed to go to a Scared Straight program. And it got out to the public, and it went viral. So the teacher was suspended and eventually terminated, and the teacher sued. The court held that this speech did not involve a matter of public concern. And again, even if it did, that the district's interest in the efficient operation of schools outweighed the teacher's First Amendment rights. Another case, Monroe versus Central Bucks School District, 2015 case. This one went up to the U.S. Court of Appeals for the Third Circuit. In that case, the teacher had a personal blog with only 9 subscribers, okay? She didn't have a very popular blog. And maybe that gave her a sense of anonymity, but we know that nothing is truly private on the internet. Her blog didn't even say where she lived or where she worked. And so she made some comments, and she came up with this kind of post that she probably thought was funny about the canned comments that you can pick for grading. For example, you write a certain number that means cooperative in class. But she made up her own list of canned comments that she wanted to say to parents. And you can probably see where this is going. Her canned comments included a complete and utter jerk in all ways, although academically okay, your child has no other redeeming qualities. Nowhere near as good as her sibling, are you sure they're related? Lazy a-hole, rude, belligerent, argumentative, expletive. I called out sick a couple of days just to avoid your son. And there's no other way to say this, I hate your kid. It didn't stay private. I should say it was also full of complaints, and this wound up being very important in the case. It mentioned in particular a girl in the back in pink who allegedly cheated. And that was enough information ultimately that people could identify who that was, because the blog started circulating on Facebook, and eventually it reached the news media. And parents were obviously very angry. In fact, it was so contentious that the teacher had to be escorted from the school out of concern for her own safety. And it made national news. Somehow, she continued teaching there for about a year and then ultimately was fired. And she sued the school under Section 1983, which alleges violation of constitutional rights. She said the school retaliated against her for exercising her First Amendment rights. So the first step in the district court is the federal district court, so that's kind of the trial court level. The first step of the court's analysis was, is this a matter of public concern? And the court talked about that standard, but didn't squarely decide because it was in that, the court at least felt it was in the gray area. The court said some posts addressed issues of public concern, but the teacher's tone was likely to generate a strong reaction from anyone connected with the school who read it. And although no names were used, students would be able to identify classmates in some posts. And the court found that it was really more complaining than discussing any bona fide education reform issues. So the court held that the teacher's speech was both in effect and tone sufficiently disruptive so as to diminish any legitimate interest in its expression. And so the expression was not protected. So she appealed and went up to the Court of Appeals. And on appeal to the Third Circuit, the court noted that the court below had not specifically figured out whether it was a matter of public concern, but reached that even if. So even if this was a matter of public concern, and we applied that Pickering balancing test, then that scale, that balancing test, weighs in the school's favor because the speech was obviously disruptive, and the teacher's interests, the court found, were entitled to at best minimal weight, So the lower court's finding in favor of the school was affirmed, the speech was not protected, the teacher could be fired and had no viable claim against the school. Those are the cases. So what happens when it's a teacher in your school? What do you do as a practical matter? One thing you want to do first is consider whether any of your school policies have been violated. If you have a violation of school policy, then that may provide an alternative basis for discipline and help insulate the district from a First Amendment claim. So perhaps this speech violates an employee conduct policy, a social media policy. Maybe it violates FERPA and privacy laws. If you've got a teacher identifying students, even if not by name, but in some other fashion that would allow others in the class to know who they're talking about, then they may be violating privacy laws, and that in itself could be grounds for the discipline, which just strengthens the school's position in the event that the teacher challenges it. You also want to evaluate how disruptive this particular speech or social media post is. Was this something directed at students or about students or a colleague with whom they regularly interact, or which may lend more toward discipline, or something really completely unrelated to the school that wouldn't have the likelihood to disrupt the district? Is the speech going to interfere with the employee's ability to do their job? Have students or parents complained, or the public? Even though it may seem like it shouldn't matter, it does matter how public it is. If this is an incident or a post that maybe was posted on somebody's Facebook and no students or members of the public saw it, but another teacher is friends with them and pointed it out, and you approach the teacher and they take it down, and that's everybody that knows about it, that is a factor. And the courts recognize that. The Third Circuit and Monroe recognize that parent and student reactions are relevant to weighing the disruption and applying the Pickering balancing test. So in terms of best practices, your school may wish to adopt a social media policy and educate employees about that. A policy is no good if nobody knows that it's there or how to comply with it. So hopefully the idea is that if you have a policy and you educate on that policy, that you can avoid these worst case scenarios and provide some guidance if you do have to discipline in response to a social media post. There are a lot of different ways to draft a policy, and you want to balance First Amendment rights. You can't ban speech. You cannot ban the use of social media altogether, but you can make expectations clear and you can set some limits. You can make it clear to your employees that they should assume that anything they post online will be seen by the school, parents, teachers, and the press. Again, you would think by now people would know this, but as is clear from the cases discussed today, some people still don't know this. You should make clear that employees are not allowed to post photos of or identifying information about any students. That leads not just to the issues we have here, but again, violations of privacy laws. You can prohibit the use of social media during the school day so that you don't have teachers actually on Facebook when they are at work. You can also require that employees not use school email addresses on social media. Many schools take the policy and offer some guidelines. So some may just discourage employees from communicating, friending, following students on social media. Other schools will outright prohibit it. You may encourage responsible posting, make it clear that, once it's online, it's forever. Deleted tweets live forever. Snapchats can live forever. Nothing is temporary and everything can come back to haunt you. And encourage and educate on using strict privacy settings and avoiding location tagging or geotagging, where it may inadvertently post, somebody may post something and it may link that it's at the school, and that could lead somebody associated with the school to find it, even if that person's own social media account really has very few followers and maybe isn't used a lot. So again, even though still nothing is truly private, smart use of privacy settings and avoiding those geolocation tags can also sometimes limit the exposure of social media posts. So a question that I've been asked as well, flipping the question around a bit, is whether you should check social media before you hire somebody. So if you're interviewing for positions, should you look at the applicant's Facebook pages? Lots of people do it, but there are some risks with it. The biggest risk is that looking at that may disclose information about that person's membership in a protected class that would not be obvious from an in-person interview. For example, if the applicant is pregnant or has a large family, going to family status. So if they're not hired and you happen to mention during the interview that you saw something on their Facebook page and they link that, they could come back and say, you didn't hire me because you found out I was pregnant. So if you just avoid knowing that stuff, it eliminates that possibility. You also want to watch out if you are outsourcing your background checks. And not a ton of schools do this, but it can be done where you have a third party do that kind of check and look at social media. And that creates not necessarily other problems, but some other hoops you have to jump through, because then you're required to comply with the Fair Credit Reporting Act. And that requires companies performing background checks to take certain steps to ensure that the information is accurate, to have a dispute resolution process, and actually obtain written permission to perform that check and tell the applicant if an adverse decision is taken based on that background check. So there's just a lot more you have to do if you are having a third-party company do background checks for you. A couple other tips, just more practically, is that teachers can have teachable moments too. So you may have a frankly minor social media mistake that is brought to your attention that can be used as a learning opportunity and maybe doesn't require discipline, but maybe is an opportunity for that person to learn. And not all violations are created equal. The resulting discipline will not always be the same. It's definitely a case-by-case analysis and depends on a lot of factors, from the content of the speech in terms of not only just whether it's a matter of public concern, but what it says and how disruptive it is to the school and how much public attention it has garnered. And those matters that go viral and are on the news, they need to be addressed swiftly. It's not something that you want to let sit around. You're going to want to deal with it, get the union involved early if that's applicable, and address it as soon as possible. So social media clearly can be a powerful tool, but schools have to be prepared to address these issues that could disrupt the educational process. The little comic there, because I always like to include a comic if I can, just says, if you can't beat them, and it has the teacher at the front with his smartphone saying in text talk, isn't this great? Text me your homework, TX, thanks. And quickly for your reference, a little bit about Foster Swift School Law Services. We provide both general counsel and special counsel services. General counsel being we do everything. Special counsel meaning that a school may hire us to deal with one particular case or issue, or even, if, for example, if one particular action that happened in a classroom has gone viral, we've had that come up. Also for some schools, we just handle their FOIA and Open Meetings Act issues. For all these services, whether general or special counsel, we have very competitive rates, and we do not charge an annual retainer, and everybody gets access to all of our educational materials. So quick summary here of some of the school law topics that we do cover, as well as a note there that we will provide on-site training for school staff on any legal topic, including social media training, social media policy drafting, FERPA, school student privacy, and FOIA and Open Meetings Act. So if you ever have a need, my contact information is here again. Please don't hesitate to call. And I think we're coming in right around 30 minutes, so I appreciate everyone being here. And if you did send a question, I will be sure to get back to you. And I hope everyone has a great afternoon.